Okay, I'm sorry. So, I'm going to chair until somebody else gets here, and then I will gladly relinquish the microphone at that point. Okay, so House Bill 182 is on our agenda today, and Vice Chair Atwood is ready to present House Bill 182.
Nothing but big hat, no cattle, Mr. Chairman. Ladies and gentlemen, Mr. Chairman, ladies and gentlemen, the committee asks for your favorable consideration of House Bill 182. This is Chairman Weldon's bill. I co-sponsored the bill, and he's asked me to present it to you today since he is not able to be with us right now. I bring your attention to lines 31 through 33. That's essentially the change of the bill. And we're asking that what we previously had in place, whereby a rehearing could be ordered by a judge at any time, except for probable cause hearings and detention hearings, shall be ordered if a party files a written request, therefore, within 5 days after receiving a copy of the order of the associate juvenile court judges. Since this was originally in place, there has been placed a legislative requirement on all juvenile court judges that they, in fact, be attorneys. And so this has the support of our juvenile court judges, and it's simply moved to, one, save taxpayers money, and to a little bit of judicial economy, and not require a second hearing where that second hearing is in fact not needed. It doesn't take away appellate rights or anything else, and we've got Judge Henry with us that can also answer questions, as well as other distinguished guests. With that, I will render for questions.
Representative Holcomb.
Thank you, Chairman Neal. Vice Chair Atkinson, I'm sorry, can you just repeat it? I did not follow you in terms of the explanation, in terms of the attorney. I'm sure I'll understand. I just didn't hear you.
What they used to have in place was, before the juvenile court judges, and correct me if I'm wrong, Judge, please, they had a safeguard whereby if an associate juvenile court judge, who was often not an attorney, made a ruling that a citizen disagreed with, they could appeal that if they gave notice within 5 days. The juvenile court judges feel that that's needless at this point, is my understanding, and I've gotten calls from several of them because that's a safeguard that we no longer need, since all of them are required now to be attorneys.
Got it. Thank you.
Any other members have a question for Vice Chairman Atwood?
Thank you, Mr. Chair. Thank you, sir. So would there, just make sure I'm understanding this, would there ever be another reason to have a rehearing besides it being a non-attorney in the past?
Not that I could think of, no. I cannot think so. And I'll certainly open it up to our judges that are here. And excuse me, Mr. Chairman, there's also a Section 2 that in the event of disqualification or other issues, absence of the judge of the juvenile court, the judge of the juvenile court may appoint any attorney at law resident in the judicial district in which the court lies, or senior judges, or any duly appointed juvenile court judge, or any duly appointed associate juvenile court judge to serve as a judge pro tempore. I forgot to add that. We've added one small section, or any duly appointed associate juvenile court judge. And
to respond to your question, anytime if you're dissatisfied with the opinion, you could ask for a motion to reconsider from the judge. It would just be heard by that same judge. And then if you're dissatisfied with that, there would be a right to appeal from a decision of an associate judge or a juvenile court judge under this legislation.
I mean, the normal processes are in place, and nothing's being taken away there. I'm sorry, I wasn't clear, I don't think, on that.
When it started out, the associate judge, you could be an associate judge if you're a graduate of law school or a member of the bar. In 2007, legislation was changed so that now to be an associate judge, you have to have the same qualifications to be a juvenile court judge. And so now, with all the same qualifications, the same continuing educational requirement, there's really no distinction in the qualifications between the associate judge and the juvenile court judge, and it just doesn't seem an efficient use of judicial time or economy to get a second bite at the apple, so to speak.
Thank you, Judge. By the way, members of the committee, Judge Bryant Henry from Walker County, my judge. Thank you, Judge Henry, for being here. Appreciate not only your work in Walker County, but your willingness to work on the state level as well. We thank you very much for that. Representative Aller.
I was going to make the same point, just to clarify that you can ask for a rehearing anytime based on new evidence, based on something that was compelling to the judge to give a right to a new hearing. And this 31 through 33 doesn't make any sense anyway, since it's discretionary.
Right.
It says the rehearing may be granted. So deleting it makes any sense. My question really is about, I've forgotten this. If I knew it at any time, I've forgotten what the difference is between an associate juvenile court judge and a judge pro temp. And that seems to be what you're getting at in lines 41 and 42.
Typically, in line 41, 42, I'll explain that a little bit better. A judge pro tem typically is appointed maybe for a specific case, whereas an associate judge, for example, in Fulton County, I think there are 5 full-time associate judges.
They are in DeKalb. They're in DeKalb too, associate judges. That's why I was.
It's not. It's more of a. Here, any cases that come before where a pro tem may cover for a day or something like that, or for a specific case. And the reason that second section is in there, it talks about who can serve as a pro tem, and it limits, can be an attorney within the judicial circuit, can be another juvenile court judge, and it does not allow an associate judge from an adjacent circuit to come in and sit as a pro tem next door.
And in DeKalb County, the Superior Court judges appoint the juvenile court judges.
Right. That's statewide. And then the juvenile court judge appoints the associate judge.
And the pro temps.
And the pro temps. But what happens, for example, I'm in Lookout Mountain Judicial Circuit, and we have Dalton next door. If the juvenile court judge and have to recuse themselves in Whitfield County, and they would like to use Judge Giglio, who's an associate judge in Catoosa County, to come in and hear a case, they can't do that. And what happens is that normally when juvenile court judges recuse themselves, another juvenile court judge will go hear that case. We don't charge anything for it. It's a good use of judicial.
And you're confident that this does not undo the requirements that you put into statute previously?
No, it will not undo that.
Because this says anybody may be appointed an associate judge.
To sit as a judge pro tem, is what that
Okay.
You're correct. You're correct. There's no comma.
Representative Towton.
Quick question. How far or how high this appeal process go since the Superior Court judge appoint these judges? When an appeal process is happening, does the appeal go as high as the Superior Court?
That doesn't go. We're a court of record, and appeals would go to the Court of Appeals, generally from juvenile court, and then it could be reconsidered by the Supreme Court.
Supreme Court.
So the Superior Court judges don't review any decisions we make. It goes to the appellate level just like an appeal from the Superior Court.
Okay, good. Thank you.
Representative Braddock.
Thank you, Mr. Chair. What is, on line 36, what is emolument?
I don't know.
Okay. So it's not just me? Okay, thanks.
I don't know what that is. No.
Google it.
I never thought I would have to go to Black's Law Dictionary to look something up. That was previously in the statute, so I don't know. I will find out. You're smarter than me. What's a emolument?
Google's great. Google's great. A salary fee.
I'm hearing it's about compensation.
Yes.
That's what our wonderful mind here in Lake Council sharing with me. There's a reason why we have brilliant people that sit beside us.
I guess the reason we don't know is when we go to another county and sit, we generally don't charge anything, so we don't fall in that definition.
Representative Spencer.
I wave. We were talking about the emolument question there.
I think it may be a riparian rights issue or something. I'm not sure.
Any other questions from the members of the committee? Anyone else want to speak to the bill? If you could introduce yourself to us, please.
Yes, sir. I'm Brad Boyd. I'm the Chief Judge in the Fulton County Juvenile Court, and both of these, the provisions of this bill are affecting us pretty significantly at the present time. We get a number of requests for rehearings, which simply adds one more proceeding to a case, and it still can be appealed. While it's discretionary for the judge to request it, if it's requested by a party, it's mandatory. So it does simply put a proceeding in place that is really kind of extraneous, because if I do a rehearing of an associate judge's order, that's still appealable. So it simply puts something in place that sort of adds another bite to the apple for either side, and the process really doesn't. The process by which it's done is supposed to be a de novo proceeding, which is a new determination on the record, which means that what I have to do is sit down and read a transcript and look at exhibits and documents and make a decision from that without having the witnesses before me, where I can judge their credibility and so on. So it's really to me, it's a kind of crippled process for even making a decision, which is sort of stuck in the middle of the regular court processes. And as Judge Henry mentioned, I earned these gray hairs for a long time. I remember when there weren't associate judges, they were referees, and those were the officers of the court that had lesser qualifications than judges. And now that we have associate judges that are equally qualified to judges, I think it's this provision that we're asking to be struck is extraneous and no longer needed. And as to the use of the associate judges in Section 2, right now in Fulton County, we're down one judge. We're trying to, and we have our associate judges busy. We have some part-time pro tems coming in to hear cases. But I've had offers from adjoining counties to come in and help us out until we're back to full staff. And the associate judges, even though we have associate judges in DeKalb, in Douglas, in Clayton, they can't come help us. And they would be available to do it, and so it's hampering us significantly in the kinds of ways we can get some assistance during this period of time when we're short a judge. So that would be very helpful to us as well. If any lawyer in the circuit and any judge in the state can come in, then it would make sense that an associate judge who's equally qualified in terms of their training as a judge should be able to come in and help us as well.
Thank you, Judge. Any other witnesses like to testify to the bill? Do I hear a motion? We have a motion to pass. Second. All in favor, please say aye. Aye. All opposed, like sign.
She's on the phone. She's on the phone.
Representative Jones, we have a vote. Do you oppose or support the bill? Okay. We're unanimous. We have due pass on House Bill 182. Thank you. We're adjourned.